Hi, everyone. I'm very happy to be here today in this exciting conference that is more relevant than ever in these challenging times. My name is Yali Shereshevsky, and I'm a postdoctoral fellow at the Federman Cybersecurity Center at the Hebrew University of Jerusalem. The research that I'm presenting today is a real work in progress. And in addition, it's situated in the periphery of cybersecurity research. So I hope that you will find my presentation interesting, and I'm really looking forward to any comments. I added my email to the last. So let's begin. This project, which focuses on the equal application of the law to military enhanced soldiers, is part of a larger project together with Yuval Shani and Loam Lubel that looks at different legal aspects of military enhancement, and I will briefly address some of these issues in my presentation. Often, presentations that address new technologies begin with a reference to science fiction. In the context of human enhancement, characters like Captain America or Robocop, which will appear later on in this presentation, are used to engage with the audience. Here, I want to do something a bit else. I want to start with the past rather than the future. In 1899, the use of expanding bullets was prohibited. Britain was one of two countries that opposed the ban, arguing that the use of such bullets is necessary in colonial wars. In a much quoted paragraph, Sir John Charles Ardagh, who served as military technical advisor to the British delegates to the first Hague Conference, explained this necessity, and I quote, "In civilized war, a soldier penetrated by a small projectile is wounded, withdraws to the ambulance, and does not advance any further. It's very different with a savage. Even though pierced with 2 or 3 times, he does not cease to march forward, does not call upon the hospital attendants, but continues on, and before anyone has time to explain to him that he's flagrantly violating the decision of the Hague Conference, he cuts off your head. For this reason, the English delegate demands the liberty of employing projectiles of sufficient efficacy against savage populations." This awful argument, which was criticized even in 1899, used alleged characteristics of a specific group of people to justify unequal, harsher application of the laws of armed conflict towards this. There are clear differences between such a racist argument and the discussion of military human enhancement. Nonetheless, the contemporary legal discussion of human enhancement revives the question of the equal application of the law to different groups of soldiers, and this is the focus of my presentation. I will start with a brief description of military human enhancement, continue with an overview of the legal discussion of such enhancement, and the main part of my presentation will be dedicated to the question of the equal application of the law to military enhanced soldiers, focusing on the legality of certain weapons and the prohibition against torture. While I still have more questions than answers, I will try to present an initial argument that supports the equal application of the rules to military enhanced soldiers. Okay, so military enhancement. I do not want to focus too much on the definition of human enhancement, which is the subject of a continuous debate that focuses to a large extent on differentiating between enhancement and treatment. For the purposes of my study, I use the definition of human enhancement as soldiers that undergo efforts to improve performance, appearance, or capability besides what is necessarily to achieve, sustain, or restore health. In the slide in front of you, you can see specific types of enhancement that were presented in a recent study. In this study, the DoD study group on bioethics described the relatively near future of enhanced soldiers. The report suggests that until 2050, the military will be able to deploy soldiers with diverse enhancement, including inter alia, ocular enhancement to imaging, sight and situational awareness, restoration and programmed muscular control through an optogenetic bodysuit sensor web, auditory enhancement for communication and protection, and direct neural enhancement of the human brain for two-way data transfer. More generally, among the different potential typologies of human enhancement categories, I find the division of human enhancement into biochemical, cybrantic, and prosthetic enhancement the most useful. The following overview of different paths of human enhancement is not conclusive, and there are many other directions for military human enhancement that are currently researched. Still, I will describe few paths of human enhancement. Biochemical enhancement of soldiers is the use of drug or other pharmaceutical agents to enhance the performance of soldiers. It is used for various purposes, including the ability to be active for long periods of time, which is highly relevant to my study, and the reduction of fear. Biochemical enhancement has a long history. It's nothing new. Militaries often use drugs to achieve different desired results among their soldiers. For example, during World War II, both Allied and Axis forces used amphetamine-type stimulants to increase their fighting capabilities. And currently, the main attention is given to the use of modafinil by various armed forces. Cybrantic enhancement of soldiers, which is the most relevant to the realm of cyber, also referred to as brain-machine interfaces, focuses on technologies that enable seamless two-way interaction between soldiers and machines, as well as between humans. Such interaction is achieved through brain implants or electrodes placed upon the scalp or skull. Cybrantic enhancement is the cutting edge of human enhancement, and much of its potential application and potential implications are not fully known. Nonetheless, as mentioned, the DoD study group on bioethics estimated that by 2050, the US military will use brain-machine interfaces that will enable soldiers to directly control assets such as drones and interact with other humans. Prosthetic enhancement involves physical improvement of the human body. There are a wide range of prosthetic enhancement, and it's a rapidly developing area of research. To give just one example that is discussed in the above mentioned study, this is a ocular enhancement. And this will enable individual soldiers to enjoy enhanced vision beyond the normal range, including, for example, infrared regions. The study group estimates that by 2050, enhanced soldiers will be able to receive data feeds of all types and across all spectra, including those previously not capable of being visualized by humans. So we can see from this short description that human enhancement has many phases with far-reaching implications, including significant legal implications. And I want now to move to a brief overview of legal questions relating to human enhancement. I would like to divide this overview to three different phases in the discussion. The development stage, the use of military enhanced soldiers, and the question of accountability for violations of international law by military enhanced soldiers. The first type are discussions regarding the development stage of military human enhancement. And these discussions include bioethics discussions on the development of enhanced soldiers, as well as discussions of the legality of their development under the laws of armed conflict. An example of a bioethic discussion in the supply chain phase is the legal importance and implications of the consent of the enhanced soldiers to the experiments in which they participate. The question of the legality of the development of enhanced soldiers under the laws of armed conflict resembles similar discussions regarding many other emerging technologies, such as the use of drones or autonomous weapons and cyber-related weapons. The use of enhanced soldiers on the battlefield, which is the second phase, raises many questions regarding the applications of the law of armed conflict and human rights law. There are many specific questions regarding different aspects of the use of enhanced soldiers. For example, one study explored the targetability of the medical personnel that provide pharmaceutical enhancement for soldiers. Another example, similar to other technologies, is the question regarding a potential obligation to use enhanced soldiers if their deployment will help to minimize civilian casualties due to their enhanced capabilities, for example, to distinguish between civilians and combatants. Another area which raises many questions is the treatment of enhanced soldiers during detention, and relatedly, the main focus of this paper, the equal application of the rules to enhanced soldiers, belongs to this phase of the discussion. Finally, the legal questions regarding accountability for violations committed by enhanced soldiers focuses on the supply chain, on command responsibility, and on the enhanced soldiers themselves. The discussion of accountability of the supply chain is very similar to similar discussions in the context of other emerging technologies, again, mostly in the regarding fully autonomous weapons. But there are interesting questions that were not sufficiently explored in the literature regarding two other links in the accountability chain. First, as to commanders, the issue of command responsibility received very little attention in the context of military enhanced soldiers. One question that was briefly mentioned relates to the relationship between individual responsibility and command responsibility. For example, it was suggested that, that through human enhancement, commanders might be able to remotely control their subordinates. And in such cases, it is highly doubtful when it's a full control that individual criminal responsibility will be assigned to the soldier in addition to the responsibility of the commander due to lack of free will. Another question with much more implications regarding the obligations of commander was not discussed in the literature at all thus far. Under the Rome Statute of the International Criminal Court, command responsibility is dependent on the ability to determine that the commander either knew or owing to the circumstances at the time would have known that the forces were committing or about to commit such crimes. It is possible that the larger flow of human-to-human data between enhanced soldiers and commanders will significantly increase the number of cases that commanders should have known that their soldiers committed war crimes, and thus will help in the quest to end impunity for war crimes. Finally, and by this I conclude my overview of the legal questions that are explored in other parts of this project. As to individual criminal responsibility, the main question relates to notions of free will and more specifically to the mental element in criminal responsibility. For example, it is suggested that some brain-machine interfaces will be able to give direct instructions to drones through subconscious mental processes. This raises significant questions clearly regarding the mental element of criminal responsibility. So we can see that there are many interesting legal questions that are worth to explore in the context of military human enhancement. And this study explores specifically the question regarding the equal application of the law to military enhanced soldiers. Here is Robocop, as I promised. Here I focus on two main issues. The first, similarly to the beginning of this presentation, is the legality of certain weapons. And the second is the prohibition against torture or cruel, inhumane, or degrading treatment. Both issues raise a similar question. If pain and suffering is an important part of the prohibition, should it stay the same? Should the prohibition be the same even if the relevant individuals, namely enhanced soldiers, suffer less? It is not an easy question. Think of the following examples. If a certain weapon is prohibited due to the pain that it causes, should it be prohibited when used against soldiers that feel much less pain due to their enhancement? Specifically, this is exactly the case regarding the previously mentioned example of expanding bullets that were prohibited due to the unnecessary pain that they cause. Or should, for example, sleep deprivation be considered torture or degrading treatment when used on enhanced soldiers that need much less sleep than regular soldiers? Let me focus here in this presentation on the question of torture, cruel, inhumane, or degrading treatment. The prohibition on the use of torture as well as cruel, inhumane, or degrading treatment appears in various areas of international law, including the laws of armed conflict, international human rights law, and international criminal. The focus of this paper is on the severity of the pain and suffering element of torture rather than other requirements that are less relevant for the paper, although I do address them in the study, but not in this presentation. The Convention Against Torture defines torture as acts that cause severe pain or suffering, whether physical or mental. The Statute of the International Criminal Court adopted a similar definition, and other treaties that address torture, such as the International Covenant on Civil and Political Rights, the European Convention on Human Rights, and the Geneva Conventions, do not define the acts that constitute torture or cruel, inhumane, degrading treatment, except for reference to non-consensual medical or scientific experiments. The definition, the above-mentioned definition of torture, as well as the definition of cruel, inhumane, or degrading treatment, was discussed by various bodies and was the subject of vast literature. General discussion of this definition or the distinction between torture and cruel, inhumane, or degrading treatment is outside the scope of this presentation. And instead, it focuses on instances in which the question of subjective application of the definition was discussed. And indeed, it was discussed by several international bodies and scholars, and they took the position that the demand for severe pain and suffering should be understood subjectively in order to take into account the experience and circumstances of the person that is subjected to such treatment. For example, in General Comment 20 on the prohibition of torture or other cruel, inhumane, or degrading treatment, the Human Rights Committee states, and I quote, that Article 7 that deals in the International Covenant on Civil and Political Rights with torture protects in particular children, pupils, and patients in teaching and medical institutions. Similarly, the appeals chamber of the International Court for the former Yugoslavia reaffirmed the position that in the assessment of torture, subjective criteria such as the physical or mental condition of the victim, the effect of the treatment, and in some cases, factors such as the victim's age, sex, state of health, and position of inferiority should be taken into account. Similar position was taken by the European Court of Human Rights many times and the Human Rights Committee. And just maybe to give one example of a case in which it was applied, so in the European Court of Human Rights, Soring versus United Kingdom case, the court took into account the age and mental state of the applicant in its decision that his extradition to face the death penalty violates Article 3 of the European Convention on Human Rights, which deals with torture. So it seems from this very short description that the current dominant position takes into account subjective factors in the assessment of the severity element of torture, along objective elements that I did not discuss here. And ostensibly, what follows is that the difference between individuals and groups should be taken into account, and therefore, acts that are severe enough to be considered as torture or cruel, inhumane, or degrading treatment of regular people or regular soldiers will not necessarily be the same, will still be considered as torture or cruel, inhumane, or degrading treatment when it comes to enhanced soldiers. Indeed, this is the position that some scholars, for example, Dinis and Kleffner, adopted, and specifically in relation to sleep deprivation, it was widely acknowledged as a practice that constitutes at least an inhumane and degrading treatment. However, when examining the literature and the actual application of the subjective approach in court decisions, it is clear that the literature and the cases focus almost exclusively on widening the protection rather than limiting the scope of the prohibition. That, for example, in contrast to the Soring cases I gave as an example, the unique ability of an individual to endure pain or the unique strength of a specific soldier are not arguments that are used by scholars or in court cases in order to limit the application of the prohibition on torture or cruel, inhumane treatment. And as I will try to explain in the few minutes that left, I believe that this difference should be explicitly acknowledged and not just observed, as I just argued, and that there are strong justifications for maintaining this difference between using subjective elements as a way to limit the ability to use certain methods and the use of subjective elements in order to limit the scope of application of the prohibition itself. Let me start by saying that it is absolutely true that sleep deprivation of those who need to sleep much less than other humans, or the infliction of pain on those who feel much less pain than other soldiers, does not necessarily fit the intuition regarding torture and cruel, inhumane, or degrading treatment. And indeed, I often, since I've started to work on this project, I often ask people about their intuitions in this regard. And in many cases, the initial intuition is that it shouldn't be regarded as torture. If someone does not feel pain, it shouldn't be regarded as torture. If someone does not need to sleep, it shouldn't be regarded as torture or as inhumane or degrading treatment. However, I believe that the discussion should take into account broader considerations and that there are strong second-order considerations that justify the application of subjective elements only to restrict the ability to use certain methods rather than to expand them. And here I want to focus mainly on two factors. I discuss it much more in depth in the study itself. So first, as some in the literature already acknowledged, the exact level of the ability to resist pain or the lack of need to sleep might not be known to the investigators, and it could lead to excessive use of these methods. Secondly, and much more importantly, allowing different treatment of military enhanced soldiers opened the door to a much broader argument regarding regular soldiers. We are well aware that there are significant differences between individuals in their sensitivity to pain, in their relative need to sleep, and in many other relevant factors. If we accept the ability to treat more harshly the stronger soldiers, such as enhanced soldiers, it opens the door to similar arguments in many cases that in which behavior that is widely considered as prohibited might be justified or argued to be justified by states in the specific case due to the attributes of the specific individual, including sleep deprivation and any other acts that were already acknowledged as constituting torture or inhumane acts. And in an area that is really open to abuse, such as torture, and we can see it in the attempts, the continuous attempts to find states accountable for torture, and the very limited success of these attempts, this is a very dangerous approach. It weakens significantly the ability to fight torture and to find states accountable for such acts. This argument can be used in many cases, at least suggesting that they thought that this is the situation. And taking into account the questionable need to use different techniques on enhanced soldiers, I lean to the conclusion that the laws should apply equally to enhanced soldiers and regular soldiers, and similar discussion is being conducted with similar results regarding the prohibition of certain weapons. As mentioned, this is a real work in progress, and I look forward to any questions and comments that you are more than welcome to send to my email address that appears right here. So thank you for the opportunity to present in this wonderful event, and I hope that you will all stay healthy and happy in these challenging times. Thank you very much.